From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Thank you so much for joining us on this Wednesday afternoon. I'm Lori Tucker, along with our legal analyst, Greg Isaacs. It's always good to see you.
Lori, it's good to be here.
We are talking about a case that really drew nationwide attention, protests, people weighing in on both sides of this case. It's the New York subway chokehold case. A guy, Daniel Penny, was acquitted this week in the chokehold death of a homeless man, Jordan Neely, who Penny had said was really agitated on the subway, and he felt he was acting, by putting him in a chokehold for 6 minutes, he felt he was acting in self-defense and also protecting fellow passengers. And the jury ultimately agreed. But it took a while to get there.
No, it did. And, it raises a really good issue as it relates to self-defense or defense of a third person. When can you defend yourself, defend a third person? And, this case really had all the different components in terms of the degree of force you can use for someone. Basically, Daniel Penny, who had a military background, was acquitted. He was charged with attempted second-degree manslaughter, well, not attempted, second-degree manslaughter, right, and reckless homicide. And there was the victim, Mr. Neely, was a homeless person who lived in New York. And had been diagnosed with schizophrenia, and he was on the subway acting in a very erratic manner.
And he'd gotten in trouble legally for being abusive and threatening on the subway before.
Right, and he was very demonstrative, and he said he didn't care if he killed himself or someone, and went to jail. So in steps Daniel Penny. He subdues Mr. Neely with a chokehold.
And other passengers were there.
Other passengers
holding his arms.
Assisted. Unfortunately, the 6-minute chokehold created a compression of the neck and was the proximate result of Mr. Neely's death.
He was also found with drugs in his system.
Synthetic marijuana.
Okay.
Some, but what the issue becomes, and under Tennessee law, it's similar to New York law. You have the right in self-defense to use that degree of force that is being used against you. So simply put, you can use the degree of force to propel that amount of force being used for you.
But that wasn't being done here.
Well, therein lies the 27 shades of gray between black and white and a eventual verdict of not guilty.
Yeah.
So did he have a reasonable belief that he himself, Mr. Penny, was in imminent danger of serious death or bodily injury, or that other third parties were? And the prosecutors didn't buy it. They said, no, you're not someone that's being a good Samaritan. You are a vigilante. You did not use a reasonable degree of force under the circumstances, and that's why they charged him. And quickly, this is one of those cases that was polarizing.
So polarizing. You saw some of the posters there that protesters were holding, calling him the subway strangler.
Right. And basically, there was, like our country in so many ways and so many times, was split 50-50 on those that felt he was justified to use deadly force and those that thought he was the, quote, subway strangler and was a vigilante. Now, interesting. So the jury got the case in October. Mm-hmm. Well, it started in October, went on for weeks, and during the deliberations, they were hung.
Now, were you surprised that the deliberations took 5 days, as long as they did? And doesn't that usually show that it might be a guilty verdict when it goes on that long?
Well, you in my experiences, you can't tell, but conventional wisdom is it helps the defense.
Yeah.
I like a jury to be in there thinking about the case,
True.
deliberating about the case.
Typically,
when the jury a verdict, they went back, came out, and not guilty for Daniel Penny.
And it was on a lesser charge, so they had looked at that in a different light.
That's true. It was the lesser charge, but it's really interesting. And when we talk about self-defense under Tennessee law, there is no duty to retreat if you're in a lawful place, behaving in a lawful manner, you are allowed to put yourself in the shoes of someone in defending a third person, but you're only allowed to use that degree of force that the third party would have been legally entitled to use. So that's what's kind of interesting.
So that is very interesting.
In this case, when you have a subway full of people, you know, if there was someone next to Mr. Neely or Mr. Neely had engaged, you know, one could argue that you would have a different degree of reasonable force that you could have used versus a bystander that was a few rows or seats away on the subway train.
Speaking of bystanders, we saw the video. The cell phones were out when this was happening, and that's what goes on in today's society. How did that figure into this
Well,
case?
today's society, court TV is on your smartphone, and you know, this is another case, and these videos are graphic, so just know as we're flashing some on the screen.
We're looking at his really final moments of life on the subway.
And we are, and those pictures really capture, when you talk about it in the abstract, and you see Daniel Penny walking in a suit and tennis shoes, you don't get the flavor of the rawness or violence of the act as Daniel Penny was literally choking out Jordan Neely. And you know, it really kind of what came to mind is some of the police brutality cases where officers were convicted in terms of George Floyd.
Yeah.
I can't breathe. And you know, when you juxtapose George Floyd with was that reasonable force, and you fast forward to Daniel Penny on a New York subway, really interesting how a chokehold or something to that effect can create a very different perception, very different result, where someone's going to jail for decades and someone is walking free in the streets of New York.
One thing about this happening on a subway, there's no out. You're there, and if this guy's going crazy, you're right there.
You're trapped. You're a prisoner in the thing. But you know, it's interesting. Self-defense is not as frequent as we think in courtrooms. But when you use it, it really puts prosecutors at a disadvantage because it kind of flips the script, because it's an affirmative defense and the prosecutors have to prove in Tennessee beyond a reasonable doubt that the defendant was not entitled to use self-defense. So, you know, instead of the defense, you know, making the state prove beyond a reasonable doubt their client's guilty, they've got to prove beyond a reasonable doubt you were not entitled to use self-defense. So, you know, oftentimes it's a very heavy burden in battle for prosecutors, but this case is a microcosm of a debate that happens with law enforcement. It happens all over this country. When can you use that level of deadly force? And I think, Lori, why these cases are so polarizing, I don't think Daniel Penny went into this altercation wanting to use lethal force.
But some are saying, why didn't you try to de-escalate the situation? And that was a pivotal part of the case as well.
Right. And again, did you act reasonably at the time, given the circumstances? And it's
he said it was impossible. He said there was no way I could talk this guy down. He was out of control.
And I think the pictures that we saw earlier, you know, can make a compelling case for the prosecutors as it does for the defense, because you can see just the rawness of Daniel Penny as you can look at the same evidence, but look at it in two dramatically different ways in terms of was this reasonable under the circumstances.
Is this it for Penny? Is he done?
That's why
no
our
has
founding
to
fathers and God created the double jeopardy clause. The only other legal impediment he may have is a civil suit, which is a much different standard. Instead of proving beyond a reasonable doubt your guilt, someone could prove by a preponderance of the evidence that he was negligent as it related to this.
Neely's father has hinted he might go that route.
Yeah. But you know, it's a much different thing when somebody's trying to stick their hand in your pocket versus someone's trying to take away your freedom. But a very interesting case, and it raises a question that we see all too frequently in the state of Tennessee and elsewhere. And really the answer is There is no answer, but 12 jurors often see the same facts differently.
This is so true. Some people call Daniel Penny a hero. Others call him a murderer, but the jury did decide. All right, let's talk more at 5:30.
Let's do it.
Thanks for being with us.